Go ahead.
Board of Appeals is now in session. The first item of business is approval of minutes. Minutes from December 10th, 2014.
I make a motion that we approve the minutes of the December 10th, 2014 meeting.
Is there a second? All in
Second.
favor?
Aye.
Passes.
Abstain.
The next item of business is election of officers. Normally, as chair, I let someone else go first, but I'm not going to do that tonight. I'm going to make the first, it's not a motion, but I think I'd like to see Victor McDonald as chairperson. Here a second.
Second.
Okay, any other nominations? Hearing none, all in favor?
Aye.
Passes 5-0. You get the gavel in a moment. You have to get vice chairperson now.
Actually, I'd like to move that Harvey take over vice chair. I can use all the help I can get.
Second.
All in favor?
Aye.
Aye.
Okay. So we need to change seats, but before we do that, when I became chair, the staff was nice enough to give me this oath for witnesses, packaged nicely. I've had it for about 14 years, and it's still in great condition. I hereby sign it to you.
So this is about as much a ceremony as we get for passing the oath,
Pass
okay?
the gavel.
You get the gavel, too.
And the gavel.
You guys can switch nameplates, so I don't get confused.
Okay, well, next on the agenda is application for a special exception. It's a special exception review. And is it
I'll introduce it.
Oh, okay, Carolyn, if you would go ahead and introduce that, please.
This is actually a biennial review of Board of Appeals case A351. This is the 15th review, and there is no public hearing required. It's just a review. The petition requests a review and extension of a special exception granted on May 5th, 1988, to allow a rooming house for 5 rooms in the R90 medium-density residential zone as permitted by Section 24-293 of the City of Gaithersburg zoning ordinance, Chapter 24 of the City Code at 109 South Summit Avenue, Gaithersburg, Maryland. In your packages, they're not really exhibits, but there's correspondence between the applicant and the board, and also a memo from Neighborhood Services Director Kevin Roman confirming that they have received their license, the renewal of their license for the rooming house, and are up to date on all their inspections. I don't know if you're here in place of Mrs. Reed. If you want to say something, just come on up to the microphone and just make sure you say your name. And
Johnny Davila, 109 South Summit Avenue,
Need to
Gaithersburg,
swear.
Maryland.
Yeah, do we need to swear?
I don't think so.
Okay.
Okay.
Go ahead.
I'm sorry, repeat your name, please.
Johnny Davila, 109 South Summit Avenue, Gaithersburg, Maryland, 20877.
This is Mrs. Reed's son, and he's here representing Mrs. Reed if you have any questions.
Any questions?
Does anybody on the board?
Well, Mrs. Reed's been coming here for a lot of years, so I think we pretty much know the background of it.
We've been around for a while.
Well, I'm going to assume from the package that's here that nothing has changed in that 2-year period.
No,
Pretty much
everything's the same. That's correct.
Okay.
Keeping tenants these days is a strong testament to them, because there's always a high turnover and a lot of apartment type or boarding house, and keep up everything is a real good thing that she's done.
Yeah, she's done a great job with that. She's got good tenants.
That helps too.
Yeah.
So, any further comments, questions? Entertain a motion.
I move that we approve the special exception, A351, the biennial review of the rooming house of Inez Reed.
Second.
All in favor?
Aye.
Aye. Do we need to read that
No.
read that into the record, or just?
No.
And basically, it's the same set of requirements that's been carried forward, I assume? Yes.
Yes.
Okay. No problem.
Thank you.
Okay, thank you.
Yeah, all we have to do is to say
We approve it.
we're going to, including the same 10 that have been there in the past.
Well, and that are listed in the
Resolution.
in the resolution. Yeah.
Any paperwork that I need to get today?
No, we'll send you some.
Okay. All right, thank you.
Thanks.
Thank you.
Have a good night.
Good night.
Right. We need to,
Do I need to close that?
well, we need to approve the draft of the minutes, no?
Of which?
Of the
The resolution?
Just
yeah.
make a motion to approve the
I'll
draft
make a motion
resolution.
to approve the resolution as written. Is that
Second?
hand up?
Somebody's got, I so
Somebody has-
move.
Huh?
The chairman can't make the
I
motion.
realize that. All right, so entertain a motion.
I move that we approve the request for continuation, A 351, permit the rooming house.
You mean the resolution? Adopt the resolution.
Right. Should I read it?
Nope,
No.
just say adopt the resolution.
Adopt the resolution. Adopt the resolution. We have to adopt it now. yeah.
Okay.
Second. Second.
All in favor?
Aye.
Aye.
Now we have a draft. Does anyone have any changes?
I thought we just adopted
We
it.
just adopted it.
It's a good thing.
That was your resolution.
Yeah, right. Okay. Yeah, we're all set.
Okay, so I think this matter is done. Item 5 on the list is, I guess, comments from staff and council representation.
Yeah, I'm going to have Lynn Board, the city attorney, come forward, and she's going to take over.
Thank you, and good evening. As Carolyn said, I am Lynn Board. I'm the Gaithersburg City Attorney, and we wanted to come before you tonight because there has been some change in representation to the Board of Appeals, and we wanted to be able to meet with you this evening and explain what's going on and why it's going on, and certainly introduce you to the people who will be here with you in the future. As you all know, Bill Chen represented the board for many, many years, I think for 20 plus years. It's been a very long time. But a couple things have changed. One, the mayor and council did authorize my office about a year ago to hire an assistant city attorney, who is Frank Johnson, who's here with us this evening. With Frank's hiring, we've been trying to provide more representation, more regular representation to all of the city's planning agencies, being the Planning Commission, the Historic District Commission, and certainly the Board of Appeals. So in the future, you will see Frank attending all of your meetings. I know he's been attending quite a few of them, but I guess starting after this evening, your next meetings, he'll be sitting up on the dais with you, and then also, providing you advice through the meetings. The second part is there will be occasions where Frank has a conflict of interest and will not be able to represent you in hearings, and that's kind of why we had outside counsel in the past. Those occasions are things like if there is an appeal from a planning commission decision to you, because Frank will have been at the planning commission and given the planning commission advice, then he can't come to you and then also represent you in those matters. So the city has retained outside counsel to provide that service for you. We did go through a competitive RFP process, which is consistent, not inconsistent. It's consistent with the city's purchasing guidelines and requirements. We hadn't done that for a number of years. So we did go through that process. There was an interview panel that was set up to vet potential attorneys who applied for that position. You certainly, Carolyn and Marty served on that panel, so we can make sure that whatever attorney retained had the expertise that you all needed in order to properly execute your duties. Alyssa Levan, who is with us this evening, was the successful bidder in that process, and she has been awarded a 5-year contract. So on those occasions when Frank has a conflict of interest, you'll see Alyssa here. So we wanted to bring both of them here this evening to introduce them to you. And I think that they would like to do just kind of a brief overview for you of just kind of some procedural issues, just kind of a reminder, and then also, they may have a little bit different style than what you've seen in the past, so, we want to make sure that sort of everybody's on board and, is comfortable, and we have the, the best process and the best representation that we can provide you. So unless you have any questions for me, I'm going to turn it over to Frank and Alyssa, and I think they're going to cover a couple issues with you this evening. Yeah.
First, you can just pass that on to everybody. I think that should be in the topics. I'm just going to talk very briefly tonight. I know some of the meetings have been 15 minutes or 20 minutes, and this may be a little bit longer than that, but hopefully not. But before I start, I don't know if you all have met our new planning director, Marty Matson, who's back here. If you would like to just say hello to folks so that they know all. This was Lauren Press. Lauren Press used to be in that position. She had left last spring, and Marty has experience really working in some different areas, different states. He's worked in Wyoming and different areas on planning issues, and so sometimes it's not just a matter of saying, well, what did we do or what did our neighboring jurisdiction do, but here's what a whole different area of the country has done, and sometimes that can be very helpful. As far as just what I wanted to say tonight, I gave you the one-page outline. Just touch on a couple of key things. The main thing is whether it's Alyssa in a conflict situation or me on a normal, when you're dealing with special exceptions, variances, and a lot of different issues that you have been dealing with. We're here to serve as your counsel. We're here to offer advice before, during, after. There can be times such as the motion you just went through. Okay, do we need to specify what it says? Now, how to do the motion? Are there some questions? That's what I'm there to do. I can help with that. Trudy certainly did fine, but I'm also there to assist with that. Again, the idea is to help you as whatever question comes up or as you need. When there's a conflict, and Lynn described when that happens, when I'm as involved in the situation that's coming up, I might have been advising staff, I might have been advising the Planning Commission, because any appeal, that appeal could come to you as well, then that's where Alyssa would step in and offer that representation, because really I'm conflicted out. Hopefully shouldn't happen a lot, although certainly glad to have Alyssa here. I don't mean to suggest that. But again, you have to have that situation, and it could happen before other boards and commissions as well. But this would be the one. You are one of the key quasi-judicial bodies that the city has. You're the one that handles not only applications, and special exceptions, things of that nature, but also appeals. And the step from you, in many cases, is directly to the circuit court. So that's where it's not just a matter, and you all recognize that. It's obvious. I've been attending your meetings for the last year, and I can see you understand that. Processes, notice, substantive law, your rules of procedure, city code, and all of those play a role. And obviously the circuit court appeals can be from any decision by any person, board or city department of the city, which has been aggrieved by any board decision. So the city code is fairly broad in who could take that step. In an appeal then, what are some of the most important things? Well, the key for any appeal is going to be the record. Any appeal is going to be on the record. Substantial evidence is the standard. And while there's a general thought that the courts ought to presume that what the city agency or a local agency did was correct, they actually in fact, don't presume much beyond what's there in the record. That means it has to be clear what that decision was. I mean, that's what you were trying to do to make sure that the record's clear. What was it? And there have been appeals, not that I'm aware of anyway, from this particular board, but sometimes involving federal agencies, can be involving some very complex issues where the courts can't figure out what was it that they decided. And in some cases, it's not clear the body decided anything. My only point there is just to say that's the importance. One of the key things is what was it? So specificity, laying it out. You certainly can adopt a staff recommendation, you just have to be clear. We adopt the staff recommendation. Sometimes it can be we adopt the staff recommendation with the following 1 and 2 suggestions. There shouldn't be a need to reread something that's already there, as long as the record already reflects it. Certainly where there are conditions or where there are changes, the more specific you are, it could be a couple of years down the road because appeals take time and somebody can look at that and figure it out. The other important part is that there's a clear basis for the decision. That means delineating not only why as a group you did it, but to some extent there can be, and sometimes it may be a habit to get into, is to say, well, in order to make sure we've got a record, let's start with the member on the end. What do you think? Tonight that might have been, well, there hasn't been a change over the last 2 years. I think we should approve it. Okay, but then it's clear that that's in the record. Then what does the next member think? I would agree with that. As opposed to simply saying motion second and done, and that may take an additional 2 minutes from the normal time, but your record then clearly delineates this is what each member thought, and then this was the vote, and that's the explanation. Those are not having that kind of a record, and obviously not here, there was no opposition, so it's not to suggest anything for tonight. But when you may have that come up, sometimes that's what a court's looking at and to say, oh, we really can't tell what the basis was. They may know what you did, but they're not sure why. That's when something will get remanded back. So that doesn't mean it was reversed. They send it back to do it again. So to the extent we can, just make sure that's clear. Those are some thoughts and ideas moving forward. Generally, I think you do that. I think you try to be as very specific in what you're doing. Most of you have been here for more than I have been. So I've been watching you for some time, and you had already been here when I had started. The other, just a few things to mention in terms of open meetings. Where there is a need to close a meeting, there is a process for that. That's part of what I'm here to help with as well. If you know in advance, sometimes it can be helpful to close a meeting before. Let's say there is a contentious issue, and there are some legal issues that need to be reviewed. If you know that's going to happen, if a pre-meeting is helpful, that can do it. We can do it that way. It can happen at the end. It's more difficult, and that's just my own perspective, to close in the middle and then come back. But where it's needed, that can happen. There also can be advice where there's not a need necessarily to close a meeting. Is it appropriate to take this step just because it might be a question of procedural or emotion or something like that? Well, actually, sometimes it might be my call. Sometimes there might be a need to say, well, if we need to have a conversation such as what's even the appropriate standard, how do we approach this, etc., then there could be a need. So I don't mean to say there may not be a need to close a meeting in the middle and then come back, but a lot of times we may find that it turns out that that's not a need. So we'll just try to, where that comes up, we'll try to work with that. The other thing just to be aware of is obviously there is the Public Information Act that everybody's responsible for. That can consist of almost anything, meeting recordings, written documents, what have you. Emails that we send back and forth. Not that it's been a big issue for our boards and commissions, but as a member of the city infrastructure, as one of our more important boards, certainly, emails also count, and they can also be included. And the last thing is procedures. Again, you are following those very well, but public hearing, as was mentioned tonight, that means public comment does have to be permitted. So even where there's nobody in the audience, is there any public comment? At least the record reflects that, and then you're fine. You do that. So that's just underscoring it. Obviously, closing the record before making a final decision. Again, not really a key issue tonight, just a procedural step. And you talked about swearing in witnesses. Agreed tonight. It wasn't contested. There wasn't a need. But it does appear that there's a contest. Go ahead, swearing everybody in makes sense. I would say that the only one thing I would say, actually, I have seen sometimes attorneys sworn in. I would not advise that, and there are a couple of reasons for that. The attorney is making an argument and actually doesn't have factual knowledge. It's better for you and the record, if anything were to be appealed, that is clear. Because then you have a record where, okay, this is what the attorney's saying in the transcript. Clearly that's argument. That's not to be taken as this is factual matter, because then that may be subject to a different level of review. Or your decision could be subject to a different level of review. So, in any event, as I was saying before, we're
There's
here.
a question.
I'm sorry,
Got a
sure.
question.
I have a question on that
Sure.
point. Sometimes the attorney may say something that you or someone else might disagree with.
Mhm.
Do we raise it at that point, or do we wait to talk to you later about it?
You mean a factual or legal argument?
Right.
At the time, if it comes out and there's a statement made, now, just because I disagree with it, if the attorney's making their case, that's okay. But if there's something that's important for how the board operates, at that point, I would raise the concern. It then kind of falls to me to say, to either respond to it, or to perhaps that could be one of those situations where we say, well, we need some further information on that. Now, that could be a matter of, is it necessary then, or maybe we need further information down the road.
One of the things I was thinking of is the attorney may make a statement that he presents as fact when, for whatever reason, we know that's incorrect. So,
Mhm. Well, if, again, the attorney wouldn't be presenting a fact, it would be, anything you say as an attorney, if it's a factual matter, there has to be some independent basis for it. So the way getting to that is to say, what's the basis for that?
okay. Yeah.
And that also can be helpful with some legal questions. I certainly, sometimes when there is a disagreement generally, just simply, what's the basis for that, or simply clarity as to what exactly are you saying or arguing or what have you, can be helpful. But anything we say, whether it's a legal opinion or a factual statement or a summary of the facts would be more accurate, there's got to be some basis for it somewhere. So, again, I look forward to working with you. I've had the chance to sit in the audience and watch, and I would also say we'll make sure that you have my email address. If you have individual questions before meetings, or if there are concerns, that's the great thing about email. Send an email, but also give me a call if you prefer that. Again, we're here to serve you, and that's what we want to try to do. So, again, look forward to it. Thank you.
Thank you.
And Alyssa, I know you may want to make a couple of comments and introduce yourself
I have
as well.
very little to add, which is good because my goal is, when you have me here in lieu of Frank, that it not be a disruptive sort of presence and it not take you out of your regular routine. Different attorneys have different styles of representing boards and commissions, but I'm going to do my best to make that happen as smoothly as possible. So I have to say I agree with everything that Frank told you. The one thing I guess I would add, and I think that Frank would probably agree with that, is that in response to Vice Chairperson Kay's question, is that you need to make your decision based on the record before you and the facts that are presented. So to the extent that you're questioning a statement of fact that's made by a party in front of you on the basis of knowledge that you have from outside, that's not the most preferable method to go, because your thoughts in your head and what you know from your outside experience isn't part of the record and isn't going to be sustainable if that's the reason for which you make a decision. So it's the job of the parties who are in front of you to present the facts, and if a fact that is presented by one side is uncontested, that may be all that you have to go on.
in which case you can't necessarily say, I've discounted this because I know that it's not true, unless there is evidence in the record to support that fact.
Well, I think one of the things that could happen here is that if one of us knows that something that is being presented as fact is not fact, we'd be more likely to say, what is the factual basis for your statement?
Exactly. I think that's a wise.
Because I think that's the approach we normally would take.
Excellent.
Okay.
So if you have any questions for me, I've been a municipal attorney for a very long time. I've represented boards and commissions in various jurisdictions. I'm happy to answer any questions that you have about my experience or any other questions you may have. No? I will also provide you with contact information in the event you need to get a hold of me as
Thank
well.
you.
Thank you.
I want to thank you all. It's very enlightening. Do we want to go over protocols and procedures at this point?
Well, that, I think that's what.
Or is that,
just was.
is that what we just covered?
That's what we
Okay, I don't think there's anything else in front of us tonight. Motion to adjourn?
I move that we adjourn.
Second?
Second.
All in favor?
Aye.
We are adjourned.